Good morning. My name is Maurice Crespi. I'm the managing partner of Schindler's Attorneys, co-founder. Schindler's is the co-founder of COBRA. COBRA is a pro bono initiative that we've started approximately 2 months ago. The moment President Ramaphosa announced the lockdown, the very next day, we started putting COBRA together. And the view with COBRA is to assist businesses in distress in one way or another, in fact, in every way possible, which includes these sessions where we can apprise the public and business owners of regulations, the situation, developments, the law. We have a knowledge base, as an example, on our website, www.cobra.org.za. We're told it is the most comprehensive and detailed knowledge base. You can go in there and type a question and it answers. And if it can't answer, you'll have one of the COBRA consultants help you. So part of the pro bono initiative is that we provide these webinars on a daily basis, sometimes twice a day. We'll soon be ramping it up. We'll have more than 2 a day. So please look out for future webinars. You'll see that we've advertised a webinar on Friday, which will be quite interesting. And that's in relation to assets, and that's by Fleet Elite. So please join us there. Today we're focusing on labor. We'll be dealing with the safety measures, occupational health and safety measures in the workplace, and we'll be looking at strategies as to how to deploy them, what they are, and some ideas around them. The session will be a Q&A platform session. We have an entire panel who will be able to jump in and answer. We say it often, why have a webinar if people do not ask questions? The point of a webinar is that we engage. So please, please, please do engage with us. Ask those questions. Now, who do we have on the panel today? We have Dan Marie, an attorney from Schindler's. She's in our labor department, and she'll be presenting today. We have Dominique Lloyd, who's similarly in our labor department and is a presenter today. She'll be answering certain questions that I'll be asking of her. And Tasneem Khan. Tasneem is from Schindler's. She puts these webinars together. Thank you, Tasneem. Emma Marseille from the IQ Business Group. Thank you, Emma, as well. Just to put IQ in perspective, IQ Business is a co-founder together with Schindler's and together with Engaged Business Turnaround. And the strategy is to help all businesses. So what we've done is we have consultants who assist at a spaza shop level, and we've got some brilliant consultants. They're leading consultants, and all the way up to big business, where IQ Business plugs in, and IQ Business can advise on all aspects of your business. And what's actually great is whilst their business model is to target big businesses, what IQ Business has been doing is using their big business expertise to assist small businesses. So bear that in mind, that in COBRA, you actually get that additional assistance, that additional expertise that one would ordinarily not find at that level of business. So yeah, that's Emma from IQ. And we have Peter Gordon. Peter Gordon is from Engaged Business Turnaround. He's a business rescue practitioner. He deals with business rescue in general. When we have our general business rescue webinars, you need to look out for those. We have one, I believe, tomorrow, and that just takes us through the fundamentals of business rescue. Gary Barachowitz, he assists in putting these together. He's a presenter himself. So welcome, Gary. Thank you for all your hard work. And Artisha, who is in the war room. COBRA has a war room to assist businesses. Artisha's there, so thank you, Artisha. So just talking labor and business rescue in general. Before I jump in and ask the panelists to deal with specific issues, I just want to mention to you that I'll just give you a broad outline of the employment relationship in business rescue. If a company is financially distressed, COBRA will assist you to stay out of rescue. That's the point. But if you go into rescue, just always be minded that employment contracts, that they apply on the same basis as they did before. And in fact, employees are afforded additional statutory protection in terms of the Companies Act. So you cannot unilaterally cut salaries. You need to engage their employees. You need to work with them. And we do that as COBRA. We mediate and we'll sit with your employees and explain the process. So that's an important aspect. Another important aspect is, which is kind of tied in with that, is that most contracts in business rescue can be suspended bar an employment contract. I'm not going to go into detail as to how to deal with the employees. That'll be for tomorrow. Today, we're dealing with the safety measures. So I'm going to ask Dom just to take us in a nutshell through the current state of the safety measures in the workplace in light of the Compliance Directive. Dom?
Thank you, Maurice, and welcome to all of our attendees. We really hope that you get practical information from this webinar. So I just want to quickly discuss the purpose of workplace compliance, and it's a very important time to make sure that this is being done. So we've obviously seen with level 4, which came into place, that certain parts of the economy were allowed to open up. And with that happening, we have employees coming back into the workspace. Sometimes those workspaces include the public, and there's certain measures that need to be taken to ensure that your employees are kept safe. So as much as people are rushing to open the doors to their businesses, and as much as people are so excited to get things going again, it's extremely important to make sure that your employees are safe, and to also make sure that any members of the public that do enter into your office space or your buildings are also kept safe and screened, which is obviously going to be discussed a little bit later. So step 1 is to make sure that all of this is dealt with before you open your doors. It's of no use if you open your doors and then start looking at what you should be putting in place, ordering resources at a later stage. So all of this needs to be done before you actually open your doors. There were certain parts of the economy which were allowed to open up in level 4, and now with level 3 coming into play, this is going to play an even more important part, because we have more businesses opening up, more people not necessarily working from home, although that is still highly encouraged. If your employees can work from home, it is an ideal scenario, because you'll see as we take you through this, it's actually a lot of responsibility in getting your workplace ready, making sure your employees have the resources necessary to keep themselves safe. And it is actually a lot of managing of people, additional to what was being done before. So it is quite a heavy task, and it shouldn't be taken lightly. And I think just by the nature of how this virus is spread, it's extremely important to make sure that all of this is followed. Just moving on to the next question, is whether this replaces the Occupational Health and Safety Act. So that act has always been in play. There's always been regulations and things that need to be put in place to make your work environment safe. That act obviously didn't include COVID. COVID is new. COVID couldn't be predicted. COVID came around, sort of out of nowhere. So the reason for these directives being put in place is to assist with this aspect of the workplace. So it doesn't replace the Occupational Health and Safety Act, but it needs to be read together with it. So everything you've been doing before to keep your workplace compliant, you need to ensure that it is supplemented and read together with the COVID aspect of it, because there's obviously extra measures that now need to be put in place. So just important, don't disregard and throw the other one in the dustbin. They do need to be read together. And then just in terms of who this would be applicable to, and we get this question quite often because some people are of the view that there's maybe certain industries or certain offices that would be exempt from putting this in place, and that is not true. If you are allowed to open your doors in level 4 and what's to come to level 3, it's extremely important for you to ensure that you have these directives in place. So you cannot exclude yourself without making sure that you've actually been through everything. It's not a decision you can take. If you're opening your doors, you need to comply with this. So anyone who is permitted in terms of section 27.2 of the Disaster Management Act needs to comply with this. So then we need to obviously move on to the most important question, which is how do I get my workplace ready? So you've been through the directives, you've gotten an idea of what needs to be done, you want to open your workplace, you want to make it safe for your employees. how do you start with this task? So the first thing to do is to make sure that you appoint a compliance officer. This person needs to be dedicated to dealing with the implementation of the COVID aspect of your workplace. We generally recommend that it's somebody who has knowledge of the virus itself. So you need to know how it's spread, because that will help you to do your risk assessments in your office place. And the person also needs to be someone who doesn't mind dealing with people in the workplace. It must be someone approachable, because this person will essentially be dealing with all of your employees, all of the questions, and obviously if there's any queries from the Labour Department, they need to be able to answer that. So once you've appointed your compliance officer, you need to stick up a poster in a open area in your office space where a lot of people would see the notice, and that needs to contain your compliance officer's name as well as their contact details, which would include a cell phone number and also a email address. So that's very important, and it is one of the checkboxes that will be ticked should the Labour Department arrive to do an inspection. Okay, then once you've done that, it's extremely important to do a risk assessment. So it's quite hard sometimes to do your risk assessment when you're not actually in the building, because you forget about certain areas. There's maybe some interleading doors that you forget about. There's high risk areas such as your kitchen areas, your bathroom areas, and it's very important for you to go through the layout of your office, to go through who's going to be at your reception, how many entrances do you have. So for example, if you have 2 or 3 entrances to your office building, it's recommended that you would then close off a majority of those and have only one entrance open to ensure that everyone is going through the reception area where the screening process would need to be attended to. So it's extremely important for you to set out your high risk areas so that you can then put a plan in place which allocates resources to those areas and also eliminates those areas if possible. I know it's not always possible to eliminate all areas, but it's very important that you identify those areas so that you can deal with them, because obviously the more we can eliminate, the easier it is, and you won't be using as many resources. You know, if you've got 3 entrances open, you're going to have a screening area at all entrances, and you're also going to have to then make sure that there's enough resources at all of those entrances. So once you've done your environmental risk assessment, you then need to look at your employees. What's very important here is that you need to make sure that you have identified your high risk employees. So that would be anyone over the age of 60 and anyone who has an underlying condition which may increase their chances of suffering more should they contract COVID. So for example, asthma is very common. In the workplace, a lot of people who may suffer from asthma, for example, would be considered as a high-risk employee, and they would then need to be included in your plan, and you would have to put measures in place to protect those people specifically. So whereas, for example, everyone in the office should be wearing a mask, you may want to put your high-risk employees into single offices where they would be kept away from your open areas, or you may want to just provide them with extra PPE or protective equipment. So for example, if your high-risk person is your receptionist, she could perhaps wear one of those clear screen masks over the other mask, the material masks. So there's all sorts of things that you need to consider in how you can protect those employees, because we know that they are high risk. Obviously, first prize is if they can work from home, they need to continue working from home. But if it is necessary for them to be in the office, it's very important for you to put extra measures in place for these people. Just very important on that aspect, you need to include the names of these people in the plan itself. But what's very important, and for the protection of personal information, is that you may not disclose the condition that somebody is perhaps suffering from, or the reasons that they've given as to why they are a high risk. So that can be kept in a separate document with either the compliance officer or with your HR department. But just be very careful when handling this information, it is personal information and it shouldn't be broadcast to everybody. So when handling that stuff, just be mindful of that. As much as we all want to make sure everyone is safe, it's good enough to say this person suffers from an underlying condition. You do not need to disclose it in a document that's, you know, floating around the office. Okay, so once you've identified who your high-risk employees are, and you've included that, you've got your areas, you then need to set everything up. So your screening areas need to be set up properly, and Dan-Marie will deal with you know, those aspects of sanitizers and masks, which is very important. But what the plan then aims to do is to also allow you to know how many resources you need to have on hand. So for example, if you've got an office of 100 people and all 100 people are in, you need to know that you need to have a sufficient amount of hand sanitizer, for example, in your storeroom. If however, you only have like a third of your workplace back, so let's say you've only got 30 people back in your office, you would then know that your resources need to be a little bit lower. And that's a massive consideration for this, because I think a lot of people forget that, you know, it's all great and well to open your doors, but it costs money to put these resources in place. And that's what this plan will help you do. And it's important to know that beforehand, because it also, you know, as I've said, it doesn't help that you open, you don't have the resources, and you put your employees back in a potentially exposed environment. You know, you're not really helping yourself, and you have the risk of one potential employee having the virus and it's spreading, and you being forced to close your business, you know, when you were so happy to get everything up and going. Another very, very important point to remember is that everyone needs to sit at least 1.5 meters apart from each other. I know this is not always possible, and open space has become very popular, and I think over the past few years it became a massive trend in South Africa, where people were putting a lot of open desk areas in place, and those are not going to necessarily be 1.5 meters apart. So in those instances, you have an option to either leave spaces between desks, which would then not afford you the opportunity to bring a lot of people back, or otherwise you can put up those perspex screenings between the desks, and then people would obviously be encouraged to keep their masks on as far as possible. This obviously then adds again to the costs of opening your business, and it needs to be done before people arrive. You can't, you know, sort of plan it. I know there's some back orders on these things, so you need to make sure that everything is ordered and put in place before realizing that it's an issue. We then also deal with biometric systems quite extensively in plans if they are part of your building. I know that a lot of those are also used for logging of time that people come in and leave the building. So if you have a biometric system in place, you either need to completely disarm it and find another way to clock your employees in, or you need to make it what we call COVID safe. It's a very, very hard thing to do, because you would technically need to be cleaning that device after every single person has used it, because a lot of those devices require you to actually touch the device, to physically touch it. So you would have to make sure that the person is sanitizing and the machine is sanitized after every use. Once again, adding to your resources, and also just creating quite a high risk area. So if you can try and do away with those types of things, it really does help to implement things a lot better. So then once everything has been planned and put in place, you would then put this into your plan. There are some guidelines in Annex E of the regulations which tell you what should sort of be in your plan, and you can then fill in the gaps. There may be some things that are not applicable to your office. You know, for example, if your office doesn't have a kitchen area, you don't need to worry about that. Bathroom areas, Dan-Marie will take us through some of the recommendations there, but you know, essentially, like, you can't use a cloth towel for everyone to be drying their hands. You need to make sure that there's paper towel, because we can't be having things in the office that could assist with the spread of the virus. The whole purpose of this is to know how the virus is spread and to put things in place to stop that from happening. It is quite a stressful thing to put in place, because you can never 100% guarantee that you are doing everything that you can, but it's important to have an idea of what you need to do and to implement it as much as you can. You know, your employees can also only be controlled so much. So it's important to educate your employees. The compliance officer is probably your best person to do that, because they know exactly what's happening on the ground. They know what people aren't doing correctly, for example. And this plan can always be adapted. It's not, set in stone that once you have this plan, that's not it and that's what you have to follow. You'll find as things start to open up and as you start to allow more people in, you may need to make more adjustments to your plan, and that can be done. There's nothing wrong with supplementing it, adding your timetables in if people are coming back in phases, or if, for example, you've got some people working in the morning, some in the afternoon, just to eliminate that risk. There's nothing wrong with you adapting your plan as you go along, and you're probably going to have to do it. It's just one of those things. We can never foresee everything, and once people are in, it is actually a lot easier to see what isn't working at that stage. So I'm now going to hand over to Dan Marie, who will take us through her bit on screening and materials.
Great, thanks so much for that. Yeah.
So now that your office is ready for occupants, we have to start talking about the employer's obligation in terms of screening their employees. So every employer must take measures to screen their workers at the time that they report for work to ascertain whether they have any of the observable symptoms associated with COVID-19, namely fever, cough, sore throat, redness of eyes, shortness of breath, for example. You must also require your employees to report if they've got any additional symptoms. These include, for example, body aches, loss of smell, loss of taste, nausea, vomiting, fatigue, weakness. And you must also require employees to immediately inform you the moment they start experiencing any of these symptoms at the workplace. In the event that your worker does present these symptoms, first and foremost, you must not permit these employees to enter the workplace or to report for work. If the worker is already at work and starts showing symptoms of feeling unwell, then first off, you must immediately isolate the worker, provide them with a surgical mask, and arrange for the worker to be safely transported in a manner that does not place other workers or members of the public at risk. And then if the symptoms are so severe, then you'll obviously need to get some medical intervention as well. You also thereafter need to assess the risk of transmission, disinfect the area and the worker's workstation, refer those workers who may be at risk for screening, and take any appropriate measures to prevent any possible further transmission in the workplace. You must also ensure that worker is then tested or referred to our identified testing sites. You must place your employees on paid sick leave in terms of Section 22 of the Basic Conditions of Employment Act. If the employee's sick leave entitlement is exhausted, then you must make an application in terms of the illness benefit that is contained in Clause 4 of the directive issued on 25 March this year, which is the COVID-19 Temporary Employer Relief Scheme. You must also ensure that your employees is not discriminated against in the event that they are showing symptoms or become ill with COVID-19. This is very much just ingrained within our values of Ubuntu, but I also think it's just really, really important to understand that in terms of Section 6 of the Employment Equity Act, you also need to take steps to make sure these employees are not discriminated against. If there is evidence that the worker contracted COVID-19 as a result of occupational exposure, then you need to lodge a claim for compensation in terms of the Compensation for Occupational Injuries and Diseases Act, COIDA, as many know it. Businesses must also be very conscious of directives specific to their industry. So, for example, retailers for e-commerce must provide written guidelines with their packaged goods for customers on how to safely disinfect their goods. So it's also very important to make sure you understand the directives applicable to your industry, apart from everything mentioned here today. In the event that one of your workers is diagnosed with COVID-19 and isolated in accordance with the Department of Health's guidelines, you may only allow that employee to return to work on the following conditions. And that is if the worker has undergone a medical evaluation confirming that they have been tested negative for COVID-19, or the employer ensures that, for example, when this person has returned, that they have extra protective equipment, they ensure social distancing, cough etiquette, that sort of thing, and they closely monitor this worker and their surrounding employees for any further symptoms. If an employee has been diagnosed with COVID-19, what the employer must do also is to inform the Department of Health as well as the Department of Labor. And you must ensure that you investigate the cause, including any control failures, and review your risk assessment if this happens. It's really crucial for you to understand where this person most likely was exposed, who else this person could have exposed, and ensure that your risk assessment is adapted the moment this has taken place. As Dominique has mentioned, sanitizers is now also regulated, and employers must ensure that every employee and persons interacting with their employees have sufficient access to a supply of hand sanitizers free of charge. The sanitizers provided must contain at least 70% alcohol in accordance with the recommendations of the Department of Health. We also see that every employer must take measures to ensure that all work surfaces and equipment are regularly disinfected before work begins and during the workday. All areas such as toilets, common areas, biometric systems, door handles, as we've mentioned, all of these things need to be assessed. If they cannot be disabled, then they need to be made COVID-19 proof. The employer must ensure that they have adequate facilities for washing of hands with soap and clean water, and make sure that surfaces that workers and members of the public come into direct contact with are routinely cleaned and disinfected. You can work all of this into your plan. Then what's also important, as I'm sure you've seen all over the news, is the provision of cloth masks. So the purpose of everyone wearing a mask is to reduce the amount of virus droplets being coughed up by those with the infection and then being transmitted to others and to surfaces. Since some persons with the virus might not have symptoms and may not know that they are actually unwell or actually contracted the virus, the Department of Health requires that all persons wear cloth masks in a public place. So in light of this, employers must provide employees with a minimum of 2 cloth masks free of charge in compliance with the guidelines issued by the Department of Trade, Industry and Competition. These masks are for employees to wear at work whilst commuting to and from work, and employers are also required to train their employees on the correct use of these cloth masks and to ensure that these masks provided as the appropriate arrangements ensure that your employees can wash them, dry them, iron them, and take care of them as necessary. We also get a lot of questions from people concerned about the fact that, especially in these very difficult times, if they cannot afford these supplies continuously for employees, and what must they do in these circumstances? Well, the Occupational Health and Safety Act states that an employer has a responsibility to provide and maintain a working environment that is safe and without risk to the health of employees, as far as reasonable and practical. So therefore, unfortunately, at this point in time, it is the cost of the company, and it will become a cost of business for at least the foreseeable future. How much time, as Dominique has highlighted once again, there's no time period specified. However, if you intend to open your doors, as an employer, you must ensure that you are compliant with the requisite health and safety measures and that your employees and general public is protected. So, and I just would like to highlight that all of this actually applies to small businesses as well as large businesses. Small businesses with 10 or less employees must also adhere to the above measures at a minimum and make any additional measures as required by their risk assessment outcome. And then, of course, your own sectoral guidelines. But for example, in small businesses where I, for example, can give an example of plumbing, you do not have an office that needs to be included in your risk assessment, but in your risk assessment needs to be included public spaces. And that's how your risk assessment needs to be adapted. And this is why it applies to sectors throughout, to businesses, no matter what size.
Okay, then if the question is this applicable to all industries? So the directive acknowledges the fact that sector-specific measures have to be taken into account, and it's therefore directed that a chief inspector, as appointed in terms of Section 27 of the Occupational Health and Safety Act, facilitate the development of sector-specific guidelines, and it must do so by engaging with social partners through the offices of the National Economic Development and Labour Advisory Council. I know that sounds quite technical, but essentially each industry needs to be assessed on its own. So for example, our medical industry will have different directives in place on how to deal with their workplace and what needs to be in place to protect those employees. You can imagine that a mining sector would be very different, for example, to an estate agent's office, for example. So there may be something specific to your industry, and it's extremely important for you to keep up to date with the directives and what is being issued for your specific industry, because it may differ from these general directives which have been issued. And these will not necessarily replace these directives, but it needs to be read together with it. So there may just be extra provisions that need to be put in place for your specific industry.
And I think just to wrap up, I would like to highlight that we get so many questions about how long will COVID-19 workplace compliance be a requirement. And to be honest with you, we foresee it for a long time, and it remains enforceable for as long as the declaration of a national disaster remains in force. So we foresee this for a while, and it's also just truly, would like to highlight also the other question we get is non-compliance, and we would like to highlight that if you are non-compliant, then with the health and safety measures may result in a business shutdown or a monetary fine or even imprisonment as contemplated in Section 38 of the Occupational Health and Safety Act. And therefore, it really is not for businesses to take this lightly. It's really important for you to get this in place and make sure that you can keep your employees and the general public safe.
Great. There's one aspect which I'd like to explore, and I don't think you guys have necessarily considered this, but what is the common law position? So if an employer, and I've got certain views on this, but I'll start with you guys. If an employer has a legal duty and the employer fails in that duty, aside from the Occupational Safety Act, we know the common law position. The common law position is if you have a legal duty and there's an omission, okay, remember the elements of a delict? If there's an omission, then you can be liable. And I seem to recall that the leading case was Yilsvis, the Minister of Police. Now, wouldn't the same apply here? Why would this be any different? Could an employer not be held liable in terms of our common law? Do you have any views on that?
Absolutely. I think that in terms of common law and delict, it's as simple as whether there is a statutory duty on you to create a safe environment, which the regulations have done. And if you omit to do that, you are also delictually liable in that case. Absolutely.
And I think it's important, I think that's a very, very important point for the public to realize, is that it's not just limited to the fines. There can be a measurable loss that you could be held liable for. And now there's another position which one need consider, and that is the common law crime of culpable homicide. So in law, if you are negligent, and by way of example, if you have a legal duty and you're negligent, you in terms of the criminal liability would be in terms of the Occupational Safety Act, but the employees themselves can be held liable for the crime of culpable homicide in circumstances where, let's say, they knew or they reasonably ought to have known that they were sick, they had the sore throat, they had all the symptoms, and they still went to work knowing of this. Now, if you're able to establish those facts in a trial, it's conceivable that there'd be a prosecution in terms of the crime of culpable homicide. If you were to do it intentionally, so if the person were to do it intentionally, then that would be the crime of murder. But there's also the in-between, which is Oscar Pistorius type, where it's dolus eventualis. So now if you know that you're kind of sick, but you think, you know what, I'm going to try and wing this, and you know that there's a very good chance and it's bordering on reckless, then you can still be imprisoned, as was Oscar. So there are greater permutations than just the regulations.
Absolutely, Maurice, and I 100% agree with you there. And we've had a lot of questions from employers asking us, but what happens if we put everything in place and our employees just choose not to follow, what we've put in place or use the materials? And I think you've hit the nail on the head with your answer there, because there's also only so much an employer can do, and as long as your employer has done everything that they need to do, there is also a responsibility and a duty on your employees to ensure that they are doing everything possible to make sure that they are not spreading this virus.
I think COBRA, we should look at actually workplace signs, just informing the employees of the risk, the common law risks. Employees may not realize that it would attract criminal liability or criminal sanction, and a very, very serious one. I think there was a case I read in the press of somebody who deliberately sneezed. And I don't know which jurisdiction, whether it was South Africa or overseas, but they deliberately sneezed, and that person was charged with murder because the individual who sneezed on died. So I was saying, as COBRA, maybe what we'll do is we'll put together some wording for signs that can go up into the workplace, just to inform employees of this risk. Employees really need to stay at home. And you'll have seen President Ramaphosa went and said, look, it's ultimately your choice whether to stay at home. It's not only a health issue, it's also a personal liability issue for the employee. And I think that's very, very important to emphasize, because it hasn't been emphasized at all.
100%, Maurice. I think that's a fantastic idea, because I think if people are made aware of the serious impact that it could have, they would take it more seriously. And, people have, I think, reached a phase of information overload. I mean, we all watch the news every day, we read newspapers, and, we're reading all this COVID stuff. But I think people don't realize the seriousness of it once they back out into the world. So it's very important for them to understand what the ultimate result of that could be.
Another question I have is, I read the Schindler's updated policy this morning, and there were some interesting features there that I was unaware of, but maybe it's in terms of regulations. But as an example, the policy is that you have to leave a red disc at your desk if you leave your desk. Is that something that's in the regulations? So the cleaners know to actually sanitize that desk in the evenings? Or is
no, so that's something that our risk assessment team puts together. Yeah.
Is that something Schindler's put together?
Yes, that's right. Yeah, it is. It's something we've put together to help us with our own internal cleaning timetable, if you can call it that, because it is very hard to keep track of when people once people have left and if their desks have been cleaned. So at least when you return to your desk, you then know if that tag is back on green, for example, that your desk has been cleaned and sanitized, and it helps the cleaners to identify that, because it's very easy for people to come and go, and it's very hard then for the cleaners to know exactly which desk has or hasn't been sanitized. So that's just a process we've put in place to make it easier to identify.
What other measures have we put in place as Schindler's that aren't in the regulations, that you haven't mentioned today as examples? Are there any others?
So some of them that we've done is, for example, some of our areas such as kitchens and bathrooms, we've tried to limit. So closing off certain areas, which I touched on a bit earlier. There's actually a lot of stuff that we recommend that's not necessarily in the regulations, but we have to also remember that these regulations have been drafted in a very rushed time. So they haven't made provision for every single aspect of your office that you need to consider. So, for example, the putting up of perspex screens in between is something that's not necessarily regulated. The 1.5 meters is regulated. So those are things that we've just adapted over time. And for example, having paper towels in between our passages with hand sanitizers in between the office areas and departments is something that we've put in place, and to stop people from contaminating across the building, for example. So it also just depends on how your office is set up, and you need to adapt. It may not necessarily be in the regulation, but you need to adapt to your office space.
So I'm just thinking out loud now. I think what we need to do is to put together these ideas in a format. We need to brainstorm, and we'll put it on the website. Just ideas as to how to implement the regulations and how to improve, because this is about people's lives. One ought not rely on the regulations. One wants to actually do better than the regulations. I personally see the regulations as a guideline, or the bare minimum that one does. but
Yes.
ultimately do everything possible. So I'd be indebted to you guys if you do that for COBRA.
Absolutely, and I think we can also add here, Maurice, is the fact that the employers actually have an obligation to put up educational material and to educate their employees. And I would like, maybe we can put together a soft bundle of that together with what you've just suggested, because it's very important for you to, because although we have an overload of information, giving your employees accurate information is what's really important at this time, to make sure they understand the virus, how it's spread, and what to do in the workplace in order to ensure that's curbed.
Brilliant. So that'll be available on the COBRA website in the next day or so. The COBRA website is www.cobra.org.za. All the webinars are there. I see on Facebook, Paul, you asked, where do we find these webinars? Paul, you'll find them on the COBRA website, and there are more. You'll see the whole host of topics that you can tap into there. And another aspect of what we've spoken about today is the fact that it's a minefield and it's difficult to maneuver. I mean, you've got two very, very competent labor attorneys taking us through them, but we have COBRA and they are members of COBRA. So if you have any doubts, if you have any questions, please contact COBRA and we'll address them. So there isn't even a need to make notes today, because you can just ask COBRA on a pro bono basis. Please, if we can take questions. I see there's one question which I'll put to the panelists, but if you can post further questions, that would be great. So the question we have here is from Jim. Thanks so much, Jim. Can you comment on, and if the employer can request information concerning your family medical conditions, etc.? How does confidentiality in terms of a person's medical history, etc., be observed? Jim, I'll jump in there and try and answer it. A individual's medical confidentiality and really relates to their right to privacy, which is a constitutional right which you can only infringe in very, very, very limited circumstances, such as incarceration, imprisonment, etc. So one's right to privacy is sanctisant, and it's very, very difficult for an employer to justify an intrusion into one's privacy. So the answer is very, very difficult. Can you ask? Of course you can ask. Can you compel a response? Can you insist on a response? Practically, what you need to consider is the circumstances giving rise to the question. If the circumstances are such that the employee suggests that, for instance, there is a condition, or there's a asthma. Let's say that the employee says, I suffer from asthma. That now is very different, because there's been a waiver of confidentiality. The aspect of privacy has been revealed. It's no longer private that the individual suffers from asthma. It's therefore, in those circumstances, you can ask, okay, thanks, can you please get a doctor's certificate confirming that? Now what happens is the employee says no. If the employee says no in those circumstances, then an inference will be drawn by the CCMA, saying, why is it that the employee said no? It would have been so easy to prove. The employee waived his or her right to privacy, and all they needed to do was to obtain a medical certificate. So it's kind of circumstances permitting, you'd be able to, but you can't just expect an intrusion into somebody's privacy willy-nilly without the circumstances justifying it. I don't know if any of the panelists want to add to that, but
yeah, Maurice, I just want to add that it's, and I did mention this on the confidentiality and how important it is to not disclose these conditions to, everyone in the workplace. And we found that the key to this potentially lies in making it a very comfortable scenario. So, sometimes people have very harsh HR departments who are unapproachable and people are scared. So if you can set up a system that makes people feel comfortable to disclose their conditions and make them feel comfortable that it's not going to be advertised around the workplace, they'll be more willing to do that. So, absolutely, yes, we can ask, but if people refuse the information, as you said, it would be very hard to force force them to give it to you, but then the risk lies on their shoulders ultimately.
Yeah, for sure. Okay, I think that's a wrap for today. I'm indebted to the panelists. I'm indebted to the attendees. I'm indebted to the Facebook audience for joining us today. We have these webinars daily as COBRA. Not only does Schindler's Presents, we have, COBRA has, I think, over 40 partners now, many of which present on Friday as an example. We have COBRA partners presenting, and that would be 2 webinars on Friday, at 10 o'clock and at 3 o'clock. You have the 3 o'clock wrap with Safiso. He's an economist from IQ Business. He's absolutely great. In fact, he's one of my favorite panelists because he's so insightful. So please join us for that. COBRA is pro bono. It's about assisting you. It's a no-brainer in my mind. Why would you not ask for our assistance? It comes free. So if you do require those one-on-one Zoom meetings with you, with your staff, if you have any questions, please don't do anything on your own. We are specialists, we are professionals, and we do this for a living. So you have us at your disposal. Don't shoot in the dark. Please come to COBRA. And the COBRA web address is info@cobra.org.za. It has a really professional ticketing system that goes into the COBRA war room that's been set up by IQ Business, and it's dealt with there. You get assigned a consultant. You, in fact, get assigned a team of professionals to deal with your particular issue. So that's a wrap. Thanks to my panelists. Thanks, everybody. Thanks to the Facebook audience. Until tomorrow. Bye-bye.